السادة الحضور، تبدأ الآن فعاليات الجلسة الرابعة والتي بعنوان الإجراءات الاستثنائية للتحكيم التجاري الدولي في ظل جائحة كورونا برئاسة الدكتور مروان المصلح، والسادة المتحدثون الأستاذ الدكتور لوكاس ميستيلز واللورد بيتر جولد سميث، بالإضافة إلى الدكتور زكري كالو والأستاذ جورج فلافيانوس. فليتفضلوا ببدء الجلسة مشكورين.
السلام عليكم ورحمة الله وبركاته. الجلسة ستكون باللغة الإنجليزية، فرجاء اللي يحب يحط الهيدفون في الترجمة أعتقد موجودة جاهزة. Good afternoon, ladies and gentlemen. Welcome to our fourth session. It's an honor to chair this session today at the fourth International Arbitration Conference. I would like first to thank the organizers, QICCA of Qatar Chambers, under the leadership of His Excellency Sheikh Khalifa bin Jassim bin Mohammed Al Thani, the chairman of the board of Qatar Chamber, and His Excellency Sheikh Dr. Thani bin Ali bin Saud Al Thani, head of QICCA. As you know, 2 years ago, in March 2020, the WHO, World Health Organization, declared COVID-19 a pandemic. Since then, all aspects of our lives changed. Due to over-changing new normal, we used to call it over the last 2 years, the new normal, the pandemic caused everyone, including arbitration institutions, to come up with creative ways to deal with the situation in order to continue moving forward. In our session today, we have 4 experts who can shed some light and share some wisdom about the challenges they faced and the adopted technology as part of exceptional procedures for international commercial arbitration amid the COVID-19 pandemic, which is the topic of our session today. To start the session, please join me in welcoming our first speaker, who's the first one on my left, the Right Honorable Lord Goldsmith, Peter Goldsmith, Queen Counsel, Privy Councillor, and he's the chair of European and Asian litigation at Debevoise and Plimpton law firm, international law firm. He served as the United Kingdom's Attorney General from 2001 to 2007, prior to which he was in private practice as one of the leading barristers in London. Lord Goldsmith has a long practice in arbitration and in the interface between arbitration and litigation. He appears as counsel for leading cases in a number of jurisdictions and different arbitral institutions, and also sits as arbitrator in London, Paris, and Singapore. Please join me in welcoming the Right Honorable Lord Goldsmith to the podium. Thank you.
Mr. Al-Musleh, thank you very much for that introduction. I want to thank the organizers too, for 2 reasons. Firstly, because I think this is a very, very good conference, a timely conference dealing with very important matters. But secondly, from a personal point of view, this is the first time I've been to Qatar since the pandemic, and what has been wonderful was to see the wealth of people here, the warmth of the welcome, and to see old friends, and I'm glad to say some new friends as well. I hope that the new friends will also become old friends. Thank you very much indeed. So the topic for this session, we think of flexibility as one of the key features of international arbitration. That arbitration can and will adapt to the circumstances of each case. But probably never before the pandemic has it been so necessary to adapt our procedures to deal with the circumstances. And in the face of strict lockdowns, the initial reaction of many tribunals and practitioners to say, well, we just can't go on, we'll have to stop, we'll have to wait. But that immediate concern was, however, overtaken by a need to ensure continuity in arbitrations. We couldn't stop arbitrations, couldn't stop dealing with people's disputes for that long. So in the early 2020, over a dozen institutions, many of the leading institutions, including the ICCI, LCIA, ICSID, HKIC, and SIAC, all released a joint statement. And that called for collaboration and open discussion in order to ensure that pending cases could continue and that parties could have their cases heard without undue delay. They were encouraged by the statement to discuss any impact of the pandemic, this is what was said to the parties, in an open and constructive manner. Well, it's understandable that in the early days of the pandemic, it was primarily left to tribunals and the parties to decide the best way forward in each particular case. But quite quickly, the institutions themselves began adopting more specific guidance. And we saw guidance from the ICC, from SIAC, HKIAC, ICSID, and the Cairo Regional Center for International Commercial Arbitration, all looking at how to give guidance to manage cases in the face of the pandemic. Most institutions didn't need at that stage to change their rules because the rules already provided sufficient flexibility. But what was needed was practical solutions to meet the necessary conditions. So the ICC guidelines, for example, included a number of appendices, such as a checklist for virtual hearings. And there are issues that you have to understand on virtual hearings. And my colleague, Professor Loukas Misteils, I think will deal in more detail with virtual hearings, and I look forward to hearing what he has to say. But overall, we saw institutions raising their game very quickly and rising to deal with the problems of the pandemic. And after the initial firefighting, after the initial shock, we settled down into a way of dealing with cases. Now, those of us who practice arbitration all have actual examples of how it was dealt with and what you needed to do to handle virtual hearings in this situation. Above all, preparation, always important for arbitration, became essential. You had to make sure that your equipment was satisfactory, that your Wi-Fi was sufficiently reliable. You needed to make sure that you didn't have a cat filter on your Zoom. And those of you who saw the luckless American attorney transformed into a cat for the purpose of a procedural hearing will know what I'm talking about. You had to do tests for the hearings, make sure that they won't be interrupted. I had one very unfortunate experience when we were very happy to have linked up the sound system to the overhead tannoy system. We thought everyone would be able to hear until there was a fire alarm, which also took over the tannoy system. Unfortunately, this was a hearing before the United Kingdom Supreme Court, who were very, very surprised that my speech was interrupted by a loud clanging noise. But flexibility and cooperation are absolutely critical to this. Let me just give a couple of examples. If witnesses are unable to dial into the event because of connection issues, you have to consider swapping the order of witnesses so as to accommodate that. Time zones can be challenging. You may need to adapt the procedures and the schedule of witnesses and speeches to take account of the fact that some witnesses or speakers would be in a challenging time zone. You could always accommodate them. We did a case, for example, in the International Court of Justice last year, where because of the global composition of the teams and the judges being in different locations, we operated on Hague time, which meant that my colleagues in New York had to deliver their advocacy at 3 o'clock in their morning. Well, never mind, we succeeded, managed with cooperation and with flexibility. So where are we heading in the future? I think that's what interests us all now. I think we're now in a transition period. Physical hearings have started again, many of them hybrid. I did one recently, lasted for about 4 weeks, and some of it had to take place virtually, and some of it was in person. And that, I think, will become more usual. But what about the longer term? Will we just go back to the way that we used to do things before? I don't think we will. I don't think we're going to go back to the old normal, as Dr. Al-Musleh referred to it, if I can butcher his words. First of all, digitalization. We will see more digitalization. We're moving away from paper even more than we have done. We've all had to learn during the pandemic to deal with documents on screen, and that will become, I think, the norm. We'll have to cope with different practical communications. We've found, for example, that we had to have methods for the tribunal to talk to itself without the parties hearing, or for the parties to give messages to each other without the tribunal hearing. And if you're all on the same virtual system, that takes some doing. But we will, I think, cope with that as well. One of the big issues that arose at the start of the pandemic was whether it was fair to have a hearing which was remote. Some people said they had a right to a hearing in person. And that was an important issue because justice does normally require to be done in public and openly. But there were two instructive decisions. One by the Austrian Supreme Court. They considered the issue as early as July 2020. There was an impartiality challenge against the tribunal who'd ordered a virtual hearing against the objections of one party. The party said that they had a right to an oral hearing, a hearing in person, but the Supreme Court disagreed. They said that if you look at the right to a fair trial, enshrined, for example, in the European Convention on Human Rights, Article 6, that includes not only the right to be heard, but also the right to have your case dealt with justly in a reasonable time. And you had to balance those two considerations, and the only way to do it was to have a virtual hearing. ICSID had to consider a similar situation, and there was a challenge in the Vattenfall against Germany tribunal. One of the grounds was that the tribunal had decided to hold a quantum hearing virtually when one of the parties thought that simply was not a fair thing to do. The ICSID Secretary General, who gave his recommendation, took the same view as the Austrian Supreme Court in saying you had to balance the considerations of efficiency and avoiding delay with the parties being properly heard, and so recommended that the challenge should be rejected. So I think what we will see as we move to the new normal will be increasing use of virtual hearings, particularly for shorter, perhaps procedural hearings. It will be very difficult to explain to a client why are you flying halfway across the world for a half-day hearing, which could be done just as easily from your office by video. I think we will find, for longer cases, people will still want to see the tribunal in person. There's nothing like seeing the whites of the tribunal's eyes, as we say, to make sure that your submissions are properly heard. So that, I think, is where we will go. And it will be interesting to come back here, which I would look forward to doing in 5 years' time, and seeing if that prediction is right. In the meantime, I thank you again and look forward to hearing the presentations of the other speakers. Thank you very much.
Thank you very much, the Right Honourable Lord Peter Goldsmith, for your views. And my next speaker is Professor Loukas Misteils. Professor Loukas Misteils is highly regarded in international dispute resolution and investment treaty law. He is a partner at Clyde & Co. International Law Firm and the Clive Schmidhoff, Professor of Transnational Commercial Law, Director of the Queen Mary University of London, UNIDROIT Institute of Transnational Commercial Law, and former Director of the School of International Arbitration from 2002 to 2019 at the Center of Commercial Law Studies, Queen Mary University of London. He is listed on the Who's Who Commercial Arbitration since 2007, the exit list of arbitrators, and is listed as one of the thought leaders in international arbitration since 2017. He is also the recipient of the GAR Award for Best Arbitration Lecture of 2013. His substantial arbitration experience as arbitrator, counsel, and expert covers ad hoc and ICC, EXID, LCIA, Ancestral, GCC, SCC, Swiss chambers, and Moscow cases, and also emergency arbitrator proceedings under the ICC rules. Please join me in welcoming Professor Loukas to the podium.
Thank you. It's my pleasure to be here, and it's also my pleasure to be here in person. And I also would like to extend my gratitude to the organizers for having put together an ambitious and indeed excellent program. In the interest of time, and not to challenge your attention span too much, I will be reducing my presentation to about 10 minutes. There is a slide presentation which I'm not going to use strictly. Perhaps a couple of the pictures on the slides would have been useful, but that's still okay. So first of all, I would like to effectively cover three topics. I would like to give you a bit of my preliminary thoughts and provide a bit of context. I will then describe the state of affairs and then see what is the role of arbitration tribunals in managing parties' expectations. So the classical picture of an arbitration case, let's say in an average value construction dispute, will involve perhaps somewhere in the region of 50 to 60 liver arts files that could easily be contained in about 10 or 12 document boxes. And that's an average case, not a very big case. There were periods in my life where all of these files have to be stored in storage rooms or in the garage. No longer. Because, courtesy of COVID, now all of these files are being transmitted electronically. And indeed, there have been trends to have that happening before. A couple of law firms for the last 5 or 6 years, they have started delivering a tablet or an iPad to the arbitrators with all the files preloaded rather than have this document submission. But the resistance was partly some people who like to work with documents, including myself, I have to say, and partly arbitral institutions that wanted to have a deposit, a paper deposit of the file. But having said that, arbitration has had hybrid elements for many years. I recall cases with video conferencing of certain witnesses going back to the early 2000s. Arbitration law firms have always had some capacity for video conferencing sort of events in their premises. But there has been reluctance to do that. And it was the reluctance to move to the level of automation that online hearings bring about. So in-person hearings on the merits have always been the norm, and hearings in some areas, construction, energy, have also tended to be very long. And you will hear advocates arguing that in preparation for a big hearing, it is the best thing to do is to leave your home about a week or two before the hearing, go to the hearing venue, lock yourself in a hotel, and prepare for the hearing. Of course, in online hearings, you still have to stay at home with your family in the background and in the other room. So what is now the state of affairs? Quite surprisingly, in a very short period of time, technology has been utilized for these complex cases. And of course, words like Zoom and Teams and WebEx and other options have been very typical to our daily life. So in the last sort of 24 months, 26 months, the majority of the cases have been online, and only a very small minority of cases have been in person. And that is for very specific reasons. For example, in one of the cases, the parties insisted on a physical hearing with all sort of the social distancing arrangements made, so ending in meeting in large rooms like this one, simply because the parties felt that there was a capacity for settlement. And the capacity for settlement is not present in the online environment because everyone is remotely. But in these online hearings, where you have the opportunity to see the other counsel, you've heard the argument, you had your day in court, then you explore other options. And of course, for some people, when there's a solution, there's a problem. There's a problem for every solution. And the insistence on online hearing meant that a lot of things were challenged. But technology has worked, and advocacy has worked. But advocacy has changed. And people had to sort of learn how to go about. So what I would like to focus in the next sort of few minutes is what is the role of tribunals in making sure that things are done right. First, what is the role of a tribunal? A tribunal has a double role, which perhaps an ancillary role, primarily to ensure due process, treat parties fairly and equally, and secondly, the efficiency of the process, and Lord Goldsmith actually already alluded to that. I would like to add this ancillary task to the tribunal. One is to educate the parties, and one of the ways that the tribunal educates the parties is by employing case management techniques throughout the process, and secondly, to instill confidence in the process. Arbitration has been democratized. The times of when a handful of law firms were controlling the majority of arbitration cases is no longer true. So you have a lot of new entrants in the arbitration business who bring with them their own baggage, that is their litigation experience, and therefore that role of the tribunal in managing expectations and educating the parties is much more critical. And given, of course, that, contrary to what a lot of my colleagues do, the role of the tribunal is to engage the parties, listen, and then decide, rather than give them templates of procedural orders number 1, 3, 4, 5 that they have already in the templates. That sort of transform a bit the dynamic. So how do we then ensure that sort of education, and how we ensure equality of parties when there's allegedly an asymmetry? And I give you a very simple example. In one of my early sort of COVID cases, it was a fintech dispute between a Moroccan party and a Nigerian party. The Nigerian party engaged a medium-sized law firm in London. The Nigerian party engaged a number of senior advocates in Nigeria and a fairly large law firm. Now, the Nigerian law firm felt that the appropriate way of having the hearing is to have a very large conference room where the main speaker was sitting opposite the screen, which is as far away from the screen as you can get. Think about Putin meeting Macron, so that level of distance. The medium-sized law firm understood that everyone had to be at their own desk for a physical hearing rather than a conference room. But as a lot of lawyers work with multiple screens in an online hearing, the camera was on the screen that was looking at the advocate from the side. So we've never seen his eyes. Not that it was critical for the case, it was critical to see the eyes of the witness. And so the tribunal had to issue an order during the hearing that witnesses have to be in separate rooms in front of a camera with a 360 level camera. So, and then what we have seen also as part of this exercise is the proliferation of new soft rules. Lord Goldsmith gave the example of the very good collaboration amongst arbitral institutions in setting out standards. A lot of law firms have done the same. But of course, all of these rules are soft rules. So what I've started working on is a code of conduct and an etiquette for online hearings. So asking sort of these very small things, sort of speak to a camera, place the camera in the right level, make sure that you are one person per room so we don't have echo issues and all of that. So balancing the parties' rights with efficiency has not always been a very easy task. Now, going forward, I think one of my major points is whether the technology we currently have will serve us, and we're going to hear about technology, or whether arbitral institutions should get together and not rely on third-party technology, but develop their own technology. We've seen, for example, the UN, UNCITRAL, using a very sophisticated system of including translation. Zoom has built-in translation, for example, as a button in their online hearing format. Opus is working on different systems. But I wonder whether one of the, in terms of security and cybersecurity, one to be expected is that arbitral institutions will have their own system. It's an emerging process. I agree that virtual hearings are here to stay, but perhaps not for the whole sort of duration of every single arbitration and not for every single hearing. So let's learn the lessons we have learned over the last couple of years and trying to invest in making sort of arbitration more efficient and greener. Thank you.
Professor Loukas, thank you very much for sharing the principles, proceedings, and obstacles to virtual arbitration hearings. Let's hear now the voice of faculty of the law school. We have Dr. Zachary Calo, as a professor of law at Hamad bin Khalifa University and member of McNair Chambers in Doha. He serves on international dispute resolution panels with Sport Resolutions UK and the Qatar Sport Arbitration Tribunal. He is also, amongst other appointments, visiting professor of sports law at Tashkent University, visiting professor at Northwestern University in Qatar, and professor at the University of Notre Dame, Australia. Dr. Zachary holds a JD from the University of Virginia School of Law, BA and MA from the Johns Hopkins University, PhD in History from the University of Pennsylvania, MA in Ethics from University of Virginia, and LLM in Dispute Resolution from Strauss Institute of Pepperdine University School of Law. Please join me in welcoming Dr. Zachary to the podium. Please.
Well, a very warm afternoon to everyone, and thank you for the organizers for the opportunity to be with you. I think I was at the last conference, which, if I recall, was at the at KICA's headquarters to celebrate the new arbitration law and how things have changed since then. What I'm really wondering is now it's about 5 after 5, and I will keep my remarks suitably brief. But I'm also curious if anybody has managed to successfully get onto the FIFA website to purchase tickets. Because I logged on at 1 o'clock, and I think my phone is still saying waiting. So if you've had success, let me know your secret. I want to offer some remarks that very much build on what my colleagues have already said, focusing on the incorporation of technology into the arbitral process and into dispute resolution more generally, but giving some sustained focus to the situation in Qatar and the region, and trying to look at both how the institutional response to the pandemic in Qatar, what this tells us about the position of dispute resolution in the region now, and where it augurs things going forward. And as has been already stated by Lord Goldsmith, in the summer of 2020, when the full implications of the pandemic were becoming apparent, a group of leading arbitral institutions, including the LCIA, the ICC, VIAC, ICSID, issued a statement encouraging arbitral bodies to continue their work by means of adopting use of digital technologies and permitting remote work and remote hearings. And many institutions, of course, as has been mentioned, had some of the technological capabilities, and they had rules that could accommodate this. But it's important, of course, to state again just how transformative the past 2 years have been, moving from something which was theoretically possible to something which has become certainly close to the norm, or at least embedded within our practice and our expectations. And this has been very much the case for academics as well, who think about and comment on the place of technology. And here by technology, I'm referring principally, though not exclusively, to the use of online mechanisms for the conducting of hearings and the transmission of documents. This was a conversation 2 or 3 years ago by academics and by commentators, but I think it's fair to say that it was a relatively marginal conversation. And just as the experience of the past couple of years has changed the world of practice, it has likewise changed how people are thinking about the future of dispute resolution as a question for research. And along those lines, what I want to focus on for a couple of minutes is some work that I did with my colleague at HBKU Law School, Dr. Barry Solomon, who's with us this afternoon. We began about a year ago to do some research into how leading institutions in Qatar and throughout the GCC had adopted technology in light of the pandemic. And the timing of our event here today is quite fortuitous. Our article, I believe, should be published as of this afternoon if the editor has done his job. It's going to appear in the John Marshall Law Journal out of the US, and it's called Alternative Dispute Revolution: Technology and ADR in the Middle East Following the COVID-19 Pandemic. So what I just want to spend a moment or two doing is highlighting at a very broad level some of the conclusions that Dr. Barry and I found. And the way we approached our research was both to look at the rules and the institutional capabilities of institutions in Qatar, in the Emirates, in Saudi Arabia in particular, but also to conduct a series of interviews to get a sense of how practices were being adopted in reality on the ground. And many of our findings will probably not be of particular surprise to those of you who work in this region, but I think it will very much be of surprise to those who are not familiar with many of the things that are happening here. I would say at a very general level what our conclusion is that institutions were very well prepared for the pandemic to adapt quickly to the exigencies of the moment. The phrase I believe we used was that many of the institutions were pandemic ready before the pandemic. That is, there was a good degree already of adaptability in place to quickly move to a more fully online operation as situations demanded. This is not, of course, a unique story. We've heard some comments on how this has played out in other institutions, so I don't want to engage in some kind of story of exceptionalism, but I do think the degree of nimbleness and rapidity that was displayed in the region is indicative of something worth reflecting on. And it strikes me that there are a couple of ways to look back at what happened and to use this as something of a case study into understanding where we are as a country and as a region in the development of not just arbitration, but an overall, if you will, dispute resolution ecosystem. I think the fact that many of our institutions are young is a significant factor, right? That many of our leading dispute resolution institutions came of age in the past decade, and so were developed at their inception with an eye towards technology, developing rules, developing practices, adopting physical space, technological resources to accommodate the things that the pandemic required, even when they weren't fully utilized. I think it also reveals a certain nimbleness of new institutions. And also, I might say, and I think this is a point that goes a bit beyond arbitration, but the relationship of arbitral institutions in the region to the broader legal system, right? We have here some very interesting dynamics that have begun to emerge, what you might even think of as a kind of diverse, almost pluralistic approach to dispute resolution, with domestic legal systems, international courts, and increasing systematic investment in arbitration and in mediation. And I think looking back at the past couple of years in light of what is happening in a broader sense in terms of dispute resolution in the region is helpful. Let me just briefly mention two examples of where we were and what happened, referencing both Kika. Sorry? 2 minutes. Very good. Well, in the interest of time, I've gotten the two-minute warning, and I don't want to steal your time. Let me just jump to a couple of concluding thoughts about where I think we need to go moving forward. Here, with particular reference to the situation in Qatar, it seems to me that the exigencies of the moment have forced procedures and practices to move more quickly than perhaps rules and laws. And we have a moment now, perhaps, to breathe and to look at the big picture and ask, what rules do we need within our institutions? What laws do we need to fully ensure that there are not gaps or potential problems in the provision of services? Lord Goldsmith alluded to some of these issues and referenced the decision of the Supreme Court in Australia. And so there isn't a lot of reason for concern, but I think one needs to be attentive to the possibility. For instance, one of the issues that is often raised is this question of an equal right to present one's case, as this language utilized in the UNCITRAL model arbitration law, including in Qatar's law. And so I think some attention needs to be given to the adequacy of that language. I will be interested to see what happens with Kika's new rules. I haven't had a chance to see these yet, but the ways in which these rules more explicitly and systematically adopt provisions for dealing with online transmission of hearings and disputes, and addressing one of the questions. I remember I had a conversation with the late Dr. Minas, whom many of us miss very much, on this question of whether, under Qatari law, parties must explicitly consent to engage in an online hearing. And his position and that of Kika was no, but there's a genuine legal question there. And so I think some attention needs to be given to closing, if nothing else, the potential ambiguities in the law. So with that, let me bring this to a close, but just with kind of a big picture thought, which is that I hope we use this opportunity now as we begin, hopefully, to emerge out of the intense moments of the pandemic and confront whatever the new legal and arbitral reality will be, and think about what this experience has revealed about where Qatar and the region is, but also what need to be the next steps and what Kika's role will be in the development of that process. Thank you very much for your time.
Thank you very much, Dr. Zach Calo, for your thoughts on technology and ADR. Now we move next to see how we prepare a case for arbitration in the face of COVID-19 from a practitioner's perspective. And we have here our next speaker, George Vlavianos. George is a partner and country head of dispute resolution at DLA Piper law firm. George Vlavianos practices in the areas of dispute resolution with a focus on contentious energy and construction matters. He also has considerable experience advising owners, contractors, and engineers on a wide range of complex multi-party construction disputes and arbitrations across the Middle East, Europe, and North America, including insurance claims arising out of large-scale construction projects. In addition, George has a significant experience handling energy-related disputes for national and international energy companies. Please join me in welcoming Mr. George Vlavianos to the podium. George.
Thank you, Dr. Marwan. I have the dubious honor of being the last speaker on the last session on the last day of the conference. So with that in mind, I think what I will keep in focus is what the bench used to say to me in my appellate advocacy career in Canada, which was, Mr. Vlavianos, get to the point. So I'd like to make a number of points. The title of today's conference, or our session, is Exceptional Procedures for International Commercial Arbitration Amid the COVID Pandemic. My contention will be that what has started, or what started as exceptional, has now become the norm. We will probably, I think you've heard this, and I would echo some of the comments of my colleagues and other speakers, that we're not going back to where we were before. Virtual hearings, 2 years ago, they weren't unheard of, but they were certainly the exception. They are now commonplace. We will have to contend with them. The use of technology, well, it was useful. It's now become utterly indispensable. Not to date myself, but I remember when I first started practicing, faxes were a wonderful thing. The older guys in the office at the time used to joke about how it was nice in the days when they practiced to receive hard copy letters, to be able to touch the paper, and when it was urgent, they would get a telex. Those days are gone. We moved from faxes in the course of my career, which is not prehistoric yet. We've moved from faxes to email technologies at your desk, to mobile devices and emails, the BlackBerry, which is now obsolete, the iPhone, the Androids, a whole series of other technologies that only my children can keep up with, to instant messaging. I remember some years ago, senior partners in the office would be horrified if clients would instruct us via WhatsApp. Now, we have sort of accepted that instant messaging is part of the way we do business. So the pandemic has accelerated our reliance on these technologies. What was exceptional has, in my respectful view, become commonplace. So what does this all mean with respect to preparing a case for arbitration? Once you file the typical request for arbitration, the quest usually begins in earnest, if not earlier, to gather lay and expert evidence in support of the case. Before the pandemic, this was invariably done in person, even when the evidence sought may not have been critical to the case. For fact witnesses, it was accepted common practice that you need to meet the individual in person, look him in the eye, assess his credibility as a witness, and take the statement in person. I remember on a number of cases flying to remote parts of the world to take statements that probably didn't take more than 2 hours. It would have been unheard of for me to suggest then that, well, we can probably do this over Teams, over Skype, or some other means. Lawyers would be flying across various parts of the world. It was great for air miles, great for the airlines, but perhaps a bit overzealous. The pandemic has obviously changed that. For expert witnesses, it was very much the same thing. You would look for the desired expert disciplines in your geographic area. You would meet with them in person, and if they were not in your geographic area, the expert would come to you, or you would go to the expert. Doing any of this remotely was the exception. Dare I say, it was anathema. You wouldn't do this over the phone. You wouldn't do this over Skype. You had to meet them in person. Those days, I think, are behind us. So, what did the pandemic do to this paradigm of case preparation? Initially, we thought the glitch would be temporary, so no need to make big adjustments. there would be a small reprieve, we thought, from the regular pace of practice, and then it would be back to normal. But as the pandemic extended and moving about, traveling to meet people and witnesses became difficult, if not impossible, the practice changed to adjust. The practice of international commercial arbitration, if it were to survive, had to adapt, and it is survival of the fittest. The profession and clients, hand in hand, we have adapted. What was exceptional, I say, has become commonplace. In-person witness interviews became the exception, not the rule. Who, after all, wanted to risk flying, traveling around only to meet with someone wearing a mask, keeping at least 2 meters distance between ourselves? Much more convenient and less risky on a number of fronts to do this by Zoom or Teams from the comfort of your own office or home. Incidentally, and I don't know about you, but I had no idea what Zoom was other than a function on my camera before the pandemic started. My wife used to make fun of me because she's a practicing psychologist, and they were at least 2 steps ahead of us because they were doing consultations before the pandemic started by Zoom. And she would point out to me, this is a great technology, and I would insist to her, perhaps somewhat sanctimoniously, dear, we have to meet our clients in person. It's not like what you do. Well, little did I know that what she does would become commonplace for the practice of international commercial arbitration during the pandemic, and in fact, as we start to get out of the pandemic. Lawyers initially resisted virtual hearings, including hearings and witness interviews, and in no time, and certainly by the spring of 2020, that had all changed. We'd adapted. What was exceptional had become commonplace, and as human beings are prone to do, we soon came to think that this was all very normal and has always been the way we do business. It's as though we had amnesia. Stepping back for a moment, it's clearly not where we started. Marathon Zoom meetings, team meetings with clients, fact and expert witnesses, all from the comfort of our offices or homes, has now become the norm. The paradigm shift is how one went about preparing a case for hearing brought other changes with it as well. I know we're pressed for time, so I just want to cover a few of these. We've become very dependent on technology, even more so than before. We need better, more robust systems to host document collections, even small ones now, as doing that the old-fashioned way, hard copies, arch lever files, and Professor Misteils' garage are no longer an option. Once documents were collected and uploaded, anyone, irrespective of where they are, could access them and work with them. This has broadened practice teams, particularly for larger matters and for the overall, I think, benefit of the clients. You could have a team quite effectively and efficiently work on a matter that had nothing to do with the jurisdiction. The team in the UK or another European jurisdiction, for instance, could participate on a country matter, and vice versa. The team in Qatar could work on a European matter and even lead that mandate remotely. In fact, I can tell you that our office here in Doha is doing just that. We currently have a large mandate in Europe and are leading on that matter in the full sense of the term, in terms of client meetings, interaction, witness interviews, and expert engagement without having visited that jurisdiction or in fact having visited the project on the ground. This would not have been possible before the pandemic. Not that it wouldn't have been physically possible, but I dare say that culturally it would have been very difficult for clients to accept that this was the way we could do business. It would have been inconceivable before the pandemic, as I say, not because it was not possible to do, but because it didn't fit the pre-pandemic paradigm of normal in terms of international commercial arbitration and how it's practiced. So before the pandemic and the blockade, I used to say, and I thought that I thought Doha was an excellent hub for international commercial arbitration. Not because all the good work was here, although there was no shortage of good work within the jurisdiction, but because it was well positioned geographically with excellent infrastructure and easy access into both other parts of the Middle East and Europe, and could support a truly international dispute resolution practice based right here in Doha. People used to look at me a bit incredulously, I must say, and say to me, well, but it's not London, it's not Paris or even Dubai. Well, suffice it to say that I get a far different reaction when I make the same observation today. And this is because there has been a global paradigm shift in how international arbitration is practiced as a result of the pandemic, how cases are prepared for arbitration, and where you need to be or not be to be able to do that. When we pitch for work that is not Qatari-based, I no longer get puzzled looks, but you're based in Qatar. In fact, half of the work that our office currently does has no connection whatsoever to this jurisdiction. This, I believe, is a clear testament to the fact that the pandemic has changed the practice of international arbitration. It has liberated it from the traditional assumptions by forcing us to challenge those assumptions and go about things differently. Very capable international arbitration teams sit outside of major centers, the major centers of London, Paris, New York. The pre-pandemic, I'll tell you a funny story very quickly, if I may. Pre-pandemic, when I hired an international associate out of Paris, one of my French partners couldn't understand why the candidate would leave Paris to come to Doha, as though there must be something wrong with the candidate. Now, maybe it was because he was French and you get that typical French attitude. He looked at me quizzically and said, mais pourquoi? Why is he leaving Paris to come to Doha? There are a lot of answers to that question, but suffice it to say that some 2 years later, I think that the skepticism, that kind of skepticism, is passé. In fact, at the height of the pandemic, we hired another associate lawyer from Paris who came to Doha. This time it was matter of fact, no questions asked. The move was encouraged as our team had plenty of work to do, and it didn't matter where that person sits physically. Wow, this was not normal pre-pandemic thinking. Clearly, there's been a paradigm shift in how we practice international arbitration. Again, what used to be exceptional has now become normal. One more noteworthy change, and it's been picked up by others, is a virtual advocacy. I'm not going to tread on the same ground that Professor Misteils has explained, but I just want to make one observation, and that is how virtual hearings have, I'll use the word, democratized the way arbitration is practiced, because we have moved, if I can put it figuratively, from Broadway to Hollywood. It's a different kind of advocacy. And what that different kind of advocacy does, and I've seen it, is it allows younger lawyers to step up to the podium to be able to do the things that would have been very difficult, out of the ordinary, unusual for them to do pre-pandemic when you were required to be somewhere present in person. So, to conclude very quickly, there's been real and significant changes in how international arbitration is practiced as a result of the pandemic. What was the exception is no longer the exception. Dare I say it's very much become the norm. Meeting clients, witnesses, and experts in person is no longer a sine qua non. Legal teams need to be where the legal teams do not need to be where the work is. They need to be able to do it wherever they are. The talent pool can converge virtually to prepare a case for hearing, which itself may very well be by virtual or hybrid means. There's been a clear paradigm shift. Is that shift permanent? I think Lord Goldsmith suggested there have been changes which I think we're not going to be able to pull back from. I'm of the same view. There may be some regression post-pandemic, if we're there, as lawyers celebrate the exuberance of being able to travel more freely once again, but human beings and clients are creatures of habit, and it will be difficult to shed entirely the habit of doing things exceptionally, which we have become so accustomed to doing over the past 2 years during the course of the pandemic. Thank you for your patience. Thank you for listening, and have a good afternoon.
Thank you. Thank you very much, Mr. Vlavianos, for sharing with us the practitioner's perspective in case management during the pandemic. I suggest that we open the floor for a couple of questions, if you don't mind. I see a hand over here in the second row. Can you bring the mic, please? And also a hand in the third row, right side. Here, excuse me, first and second. Okay?
Assalamu alaikum. I will speak in Arabic, okay?
Okay, and I think we have a translator who will translate in English. So.
Yeah. Can I give him please?
Yeah.
Okay, they have.
And can I ask that questions be directly
إذا أريد فقط أن أشاطر معكم تجربة شخصية في موضوع هذه الجلسة. في فترة كورونا خصوصا في سنة 2020 حظيت بشرف تنسيق كتاب جماعي حول القانون في زمن كورونا، وقد اخترت شخصيا أن أشتغل على موضوع التحكيم في ظل يعني ظروف الجائحة، أنا وبعض الزملاء الأساتذة الأصدقاء، وقد نشر الكتاب ويعني موجود. انطلقنا في البحث من طرح السؤال التالي: أولا البحث عن الأساس القانوني لممارسة التحكيم عن بعد. هل القوانين المقارنة أصلا يعني توجد بها نصوص تسمح أو لا تمنع من ممارسة التحكيم عن بعد ووفق أي ظروف؟ فوجدنا أنه يمكن يعني أن نميز بين حالتين أو ثلاث. الحالة الأولى نصوص قليلة قانونية تذكر مباشرة إمكانية ممارسة التحكيم عن بعد إلكترونيا، نصوص قانونية أخرى صامتة وبالتالي لا تمنع من ممارسة التحكيم عن بعد، ولكن هناك نصوص قانونية أخرى قد لا تمنع بشكل مباشر ولكن تتضمن من القواعد والأسس التي إن أعملت ستكون يعني صعوبات في مواجهة ممارسة التحكيم عن بعد إلكترونيا.
أشكرك دكتور فضل. على مشاركة هذه النتائج البحثية، بس ويمكن حضرتك تشاركنا صورة من البحث لتوزيعها على المشاركين، نكتفي بتوجيه القدر آخر من الأسئلة للأستاذ هنا second row.
Thank you so much. I promise I will not take the time. I have a small question regarding to the security of arbitration. We know that parties choose arbitration for many reasons, in fact, and I want to choose two. One, security. Second, flexibility. And I remember one of the cases last year when one of the parties alleged in front of the arbitrators that how can we trust that there is no hackers right now? We need privacy at the arbitration, so we don't want to take this step. And also flexibility. For example, some cases where parties need to be there at the place and arbitrator have to observe or see the physical facts. So my question is for anyone regarding to arbitration institutions, for example, Qatar arbitration institutions, how can we encourage parties that we have a safe method that we can use visual arbitration, online arbitration, even though we need, if we have a physical effect?
You mean secured connections?
I mean during the procedures,
yeah,
because of the privacy that we are looking for.
Got the question.
Thanks so
Thank you. Thank you very much. Anyone? Lord?
Yet again, good question. So there's two bits I think that need to be considered. One is, and you mentioned, how do you stop being hacked? And that, I know from clients were concerned that somebody might come into the arbitration virtually who was not supposed to be there. And that's an issue. And the conference providers, the platform providers like Zoom, like Teams, they had to demonstrate that they actually had secure systems that people couldn't get in. They introduced new passwords, new systems for access that were designed to encrypt access so that people couldn't be there who were not supposed to be there. So I think that's one aspect to it. The second aspect to it is, I suppose, the security of the decisions that are made. And then, of course, it's perhaps no different from in-person arbitrations, that you have to make sure that you limit the circulation of the decisions to those who are entitled to have it. So I think these are important points. You're very right to have raised them, but I believe that they've been handled, and people are more secure and more confident now that their arbitrations are secure.
Any other comments?
I have a couple of comments. Security, cybersecurity and hacking has been a problem before COVID. There are a couple of published cases, particularly exit cases, where intercepting of communications in the context of the arbitration have been an issue. Therefore, a lot of the professional associations have been looking at cybersecurity, and then we have a number of protocols developed which are quite sophisticated now and is as safe as any other hearing, I would think. Also, the technology has adapted. I had a hearing in a construction dispute where in a typical circumstance you will have a site inspection. And in that particular case, they've used a drone camera that went all the length of the highway and produced a 20 minutes video which was really showing whatever you wanted to see as a tribunal, and no one had to travel there. So I think there has been quite a bit of adaptability, and that's a nice feature of arbitration.
There we go. See, technology, right? That's my point. Now, I failed. Let me speak for a moment to your second point about, if you will, kind of the human element. I think that's what you were speaking to, the ability to see, to encounter, to confront the other people. I think this is complicated, and I'm not quite sure where the pendulum will swing. I have a feeling there will be, as some of us have mentioned, something of a retrenchment, but I suspect not an entire one, both for the practical reasons we've discussed, but I think a lot of people have also just become comfortable with the ability to find some version of that human dynamic online, however imperfect. I do a good bit of work in mediation as well as arbitration, where in some ways you could argue the capacity to be physically present is even more critical in certain moments. And there were a lot of mediators before the pandemic and in the early months saying, we can't do these online. You have to be able to see the people. You have to be physical. You have to be able to have lunch with them. And some people still believe that, but I think a lot of folks have realized, well, we're settling these disputes just as well, just as effectively, at just as high a rate. I did 2 mediations last week in the United States, high emotion cases, and we did them online. So I think there's something valuable in what you say, and there will probably be a bit of a movement back. But I think we've also adapted our expectations and maybe just the way we encounter other people in the course of our work.
Thank you, Dr. Zach, and let's see what from a private practitioner's standpoint.
I mean, I think that technology has done a good job of catching up to the practice if it needed to. My suggestion would be that it was ahead of what lawyers are doing in any event. I mean, certainly if Secret Service agencies across the world can gather data securely about people, surely to God we can have a hearing in a manner that preserves that data without compromise.
Thank you. Thank you very much. I think last question from the gentleman in the third row. Direct to the
Good
question,
evening.
please. Good
Yeah,
evening.
my name is Nagarajan. I'm heading contracts and claims in the PMCM. So I have a general question. What I understand is the arbitration is a damage control. But why don't we have a statutory body that can prevent to go into this kind of arbitration, at least to some extent, to have the endorsement from the statutory body of the contracting between the parties that could avoid this arbitration to certain extent. Not 100% you can avoid, but at least to avoid some simple issues by using this kind of a statutory body. This is my general intention, but whether it is possible to make it, and government and every organization should come into the place to make it how it is possible.
Okay, thank you. Anyone would like to pick the question?
I'll make one observation, if I may. A few moments ago, the question was being asked, what is the legal basis for arbitration? And I give a simple answer to that. It's consent. The parties have to consent to have their disputes settled by arbitration. And that means if it's consent, then they can give consent in different ways and to different forms of arbitration taking place. And if they want to consent to it being done online, if they want to be consent to it done being without any submissions at all, just a decision on papers by a chosen person, that's all possible to do. So that's how I would respond to that question.
Thank you, Lord Goldsmith. And with that, we end the questions for this session. Thank you very much, Lord Goldsmith, Professor, and Dr. Zach, George. Thank you all. Thank you.
نشكر السادة المتحدثين على ما قدموه.
Pleasure.
وأدعو سعادة الدكتور الشيخ ثاني بن علي آل ثاني لتكريم المتحدثين، فليتفضل مشكوراً. الدكتور مروان المصلح. الأستاذ الدكتور لوكاس ميستيلز. اللورد بيتر جولد سميث. الدكتور زكري كالو. الأستاذ جورج فلافيانوس. شاكرين تصورون صورة جماعية. وفي ختام المؤتمر توصلنا إلى عدة توصيات متعلقة بقانون التحكيم وأخرى بقانون الوساطة نذكرها بإيجاز. أولاً، التوصيات المتعلقة بقانون التحكيم. أولاً، تفعيل نص الفقرة رقم 10 من المادة رقم 11 من قانون التحكيم رقم 2 لسنة 2017 والخاصة بإجراءات اختيار أو تعيين المحكمين. ثانياً، تفعيل نص المادة رقم 37 من قانون التحكيم رقم 2 لسنة 2017 بشأن إنشاء سجل قيد المحكمين بوزارة العدل، ونوصي بأن تشرف على تنظيمه لجنة تشكل خصيصاً لهذا الغرض، وتضم في عضويتها أساتذة قانون متخصصين في التحكيم الدولي وممثلين عن مراكز التحكيم، وذلك لضمان تعيين المحكم المناسب لظروف النزاع حسب ما بينته المادة ذاتها، وبالتسلسل الوارد بالفقرة رقم 10 من المادة رقم 11. ثالثاً، إصدار لائحة خاصة بإجراءات إيداع الأحكام المبينة بالفقرة رقم 11 من المادة رقم 31 من قانون التحكيم، مع مراعاة مبدأ السرية والحفاظ على بيانات الأطراف وموضوع النزاع. رابعاً، إدراج شرط التحكيم في عقود الجهات الحكومية، وخاصة ما يتعلق منها بعقود الإنشاءات. خامساً، تعديل الفقرة الثالثة من المادة رقم 33 من قانون التحكيم، والتي تمنح المحكمة الحق في القضاء بالبطلان في الحالات المبينة بالمادة المشار إليها، ليكون القضاء بالبطلان بناء على طلب الأطراف فقط، وليس للمحكمة أن تقضي به من تلقاء نفسها. نبدأ بالتوصيات المتعلقة بقانون الوساطة. أولاً، نوصي أن يتم تغيير نص المادة رقم 22 من قانون الوساطة ليكون وقف المدد المقررة طبقاً لتلك المادة منذ توقيع اتفاق الوساطة، وليس بدء الإجراءات، وذلك حسب التالي: يترتب على اتفاق الوساطة وقف المدد المقررة قانوناً لسقوط وتقادم الحقوق أو لرفع الدعوى بها، وذلك حتى تاريخ انقضاء الوساطة. ثانياً، إصدار لائحة تتضمن الإجراءات التي من خلالها يتم تقديم طلب توثيق اتفاق التسوية إلى المحكمة، وبيان طبيعة القرار الذي سيصدره القاضي حسب المبين بنص المادة رقم 25 من قانون الوساطة. ثالثاً، تعديل نص المادة رقم 27 من قانون الوساطة ليكون كالتالي: تقضي المحكمة بعدم جواز نظر الدعوى لسابق حسم النزاع بالوساطة، وليس لسابق الفصل فيها. أشكر الجميع على الحضور. وهناك كلمة أخيرة فيما يتعلق بالختام. ختاماً، يتقدم مركز قطر الدولي للتوفيق والتحكيم بالشكر لمعالي الشيخ خالد بن خليفة بن عبد العزيز آل ثاني رئيس مجلس الوزراء ووزير الداخلية لرعايته المؤتمر. كما نتقدم بالشكر الجزيل لجميع المتحدثين على أوراقهم المثرية والتي ساهمت في إثراء مواضيع المؤتمر. كما أشكر السادة الحضور على الحضور، ونلتقي بكم بمحافل قانونية أخرى، والسلام عليكم ورحمة الله وبركاته.